reservation of rights becomes a very important aspect to arbitrations then. Any further discussions from the panelists?
So I just wanted to add one thing on the Astro and Lippo case, just so that we don't leave you with the impression that Singapore and Hong Kong are these two Far East countries that have gone completely different ways. The interesting thing to note about Astro and Lippo is that as far as the world is concerned, this award is valid and binding. Like Martin said, the Hong Kong court recognized when they were asked, they were sitting in their capacity as an enforcement court, and when they were looking at the issue, they categorically said the question of whether the whole issue of joinder, that's res judicata, because the court of the seat has already decided this and it's final. So because Lippo did not set aside that award is valid and binding today. It's just that Singapore chose not to enforce it and Hong Kong did. And for different reasons. Hong Kong, because of the basis of good faith. Singapore looked at the same issues, and what our court said was, and this is another thing that the Hong Kong court pointed out, the Singapore court, when it considered the issue, did so in its capacity as an enforcement court, not a supervisory court. Because if Lippo had raised this argument and it had gone to the Court of Appeal, and it had done so in the context of seeking to set aside, then there would be no valid arbitration award in that sense. But because they only did so when it came to enforcement, the Singapore court judgment is in the capacity of an enforcing court. And because of that, the Singapore court had, when they looked at the good faith arguments, they looked at the context of waiver, and they basically said they can raise any argument they want in the context of enforcement. Have they waived their right to raise this argument on jurisdiction? And the Singapore Court of Appeal considered the same things that the Hong Kong did, the sense of, look, there was substantial delay, Lippo went through the entire arbitration, so on and so forth. They chose not to set it aside when they could have, and blah, blah, blah. But basically where the Singapore court left off was, they were very traditional. They said that waiver, you can't waive your right unless it's categorically and unequivocally waived. And it's a very high threshold to be met to show waiver. And that's why it didn't succeed from enforcement. But it remains to be seen what happens in other enforcing courts. Because on one hand, Singapore is the seat, but it did not make its decision in that capacity. It made it in the capacity of being an enforcing court. And in fact, the Singapore court thought that was a very good thing. They noted that themselves quite ironically. They said that the problem with courts like Hong Kong, we didn't use those words, but essentially what they were saying was that if you force people to take the active remedy route, you basically say, look, if you're not happy with the jurisdictional ruling, it's incumbent on you to seek to set it aside if you're able to do so. The difficulty with that is you're moving away from the idea that the court of the seat should have less importance. And the Singapore court feels that the way the arbitration rule is moving, you need to de-emphasize the importance of the court of the seat. And by making people feel that they have to pursue active remedies, you're basically telling people you have to go to the court of the seat and seek to set aside or challenge a jurisdictional award. So they said this is against where the arbitration rule should be moving. So these are the kinds of concepts and arguments that have been thrown up. So if you have any questions or comments.
Do we have any further questions from the audience? All right, so on that note, when we are discussing about active remedy and passive remedy, let's go down to good old India and see what Sonal has to add. But I must say, Indian courts, this whole issue of enforcement vis-a-vis challenging the validity of an award, most of the cases that came to India, the erstwhile cases where awards were set aside, international arbitral awards, they were really the passive remedies that should have been followed for resisting enforcement of those cases. However, the courts chose to go under Part 1 and set them aside. Things have changed a lot since then.
Yes, thank you, Akshay. I know there are time constraints, so I'll very briefly touch upon the legal provisions under the Arbitration Act, which deal with the joinder of parties. And then I'll go onto the approaches of Indian courts. As Akshay has said, that it has changed over a period of time. So as far as the Indian Arbitration Act is concerned, we do not have any specific provision which deals with joinder of non-signatories to arbitration agreement, as you would find in ICC rules or maybe HKIC rules. But Certainly, there are certain provisions in which you could find the traces of intention of legislature, which shows that the legislature intended to bind or to include or to make non-signatories parties to the arbitration agreement as well. For instance, Section 45, as our keynote speaker today briefly discussed, the use of words, any person claiming through or under a party to arbitration agreement. The courts have construed that use of this word shows the intention of legislature, that they actually wanted or they thought of a situation where a third party may have to be made party to the arbitration proceedings. In a recent judgment, which I would discuss, Section 45 was discussed in detail, and it was a landmark judgment which was authored by our keynote speaker today, which is called Chloro Controls, in which the courts have interpreted, and for the first time they have recognized various international doctrines, which have said that the third parties or the non-signatories could be made party to the arbitration proceedings. But for the sake of convenience, I have divided all the judgments in two phases, and I have it's pre-Balco phase and post-Balco phase. Of course, the Balco is a landmark judgment and has set a benchmark, and since then there's a tremendous change in the Indian arbitration jurisprudence. So as far as the pre-Balco phase is concerned, I would start with Sukanya Holdings versus Jayesh H. Panda. This was a Supreme Court judgment in 2003. I won't go into the facts because of the time constraints. But in this judgment, there was a dispute that arose out of a partnership deed, where one of the parties filed a suit in the court against the other partner, and he made two other entities party to the suit proceedings. In this case, Supreme Court held that if in a dispute there are parties other than the parties to the arbitration agreement, then the dispute cannot be referred to arbitration. Also, the court held that if the cause of action or if the subject matter of the dispute goes beyond the arbitration agreement, then also the matter cannot be referred to the arbitration. This was again a subsequent case came, Indo-Wind Energy versus Westcare, in which again a question before the court came. The question which before the court was that whether a subsidiary of a party to the arbitration agreement can be made a party to the arbitration agreement, considering that it has not signed the arbitration agreement. There were facts under which it was argued by the parties that the management was same, and they were involved in negotiations. They were ultimate beneficiary of the arbitration of the contract. But the court held the fact that the subsidiary did not sign the contract or the agreement shows the intention of the parties and also the third party or the subsidiary, that it did not want itself to be bound by the arbitration proceedings or arbitration agreement. And it declined to make the subsidiary a party to the arbitration proceedings. A similar case in Deutsche Post Bank Home Finance Limited, popularly known as Taduri Sridhar case. Again, the Supreme Court said that if the party has not signed the agreement, then we won't go against the intention of the parties and make them a party to the arbitration proceedings. But things have changed since Balco. Balco was a landmark judgment and has actually marked, is a case since when there's a tremendous change in the approach of the Indian courts. After Balco, this question again came up before the Supreme Court. It was referred to a larger bench, a 5-judges bench in Supreme Court in the case of Chloro Controls versus Severn Trent Water Purification. Decided this issue, and for the first time they recognized various doctrines which my friend Alexander has discussed, and they held that in certain circumstances, we have to go beyond the requirement of the written agreement, written arbitration agreement, and have to see the intention of the parties. In this case, a US company entered into a joint venture with an Indian company. There was a master agreement or a mother agreement, which a shareholders agreement, and there were other supplementary agreements as well, which were signed between various parties and other group companies. Few of the agreements had arbitration clauses, few of the agreements did not have arbitration clauses. The court ultimately held that if the contracts or the agreements are so intrinsically related to each other that their composite performance can only discharge the parties, then in such cases, even the non-signatories to the arbitration agreement, or even the related matters, the matters arising out of agreements which do not have arbitration clauses, can also be referred to arbitration. Now that was a benchmark, now that was a judgment which has actually opened doors and which has actually adopted a liberal approach when it comes to joining non-signatories to the arbitration agreement. And after that, this approach has been followed in various cases by Delhi High Courts and Bombay High Courts as well. In a recent case before the Bombay High Court, which is titled Rakesh S. Kathoria versus Milton Global Limited, the question before the court was whether to lift the corporate wheel and include or refer the group companies to the arbitration. Of course, the group companies were not signatories to the arbitration agreement. So the court went beyond the requirement of the written agreement and relied upon various provisions of the joint venture agreement between the two companies, the signatories of the arbitration of the joint venture, and held that the intention of the parties was not only to bind the signatories to the arbitration agreement, but was also to bind the other group companies. And they ultimately referred the parties to the arbitration, and they granted. Of course, they did not grant the relief under Section 9. It was a petition under Section 9, but they held that intention of the parties has to be seen while deciding the question of joining the non-signatories to an arbitration proceedings. So as I said, that there is a tremendous change in the approach of the Indian courts since 2010, if I would say. Of course, this could not be taken as a straight, jacket formula and applied to all the cases, because the issue of joinder of parties to an arbitration who are not signatories to the arbitration agreement depends on facts and circumstances of every case. You have to go into the facts of each and every case. But it would be interesting to see how the Indian courts take this forward and deal with the issue of joinder of non-signatories to the arbitration agreement in future. Thank you.
Thank you so much. I must say, actually, chlorocontrols is pretty close to my heart, and that's purely because I was in the middle of an arbitration at that time where we were trying to include this was against an Indian company, and we were trying to make the parent company, because our client had signed a contract with basically a shell company, and we were trying to implicate the parent as a body, and we had been struggling a lot with Indovind. And chlorocontrols came about a month before the final hearing, and the matter settled a week before the final hearing. And at the same time, I must say, the point that you've made about how Indian judiciary has really become pro-arbitration, and that's very heartening to see. As an Indian qualified lawyer who's practiced in India as well and now practices abroad in international arbitration practice, I find myself at this crossroads where I'm often defending the old judgments of Indian courts. And I always say, if you look at those judgments, they're actually very good and very well-reasoned judgments, and they were always trying to do justice. They just went overboard. but the new trend is very heartening.
Speaking of the new trend, being the only Indian at the ICC court, I'm always looked upon from a jurisdiction which is not so arbitration friendly. Sitting in the courtroom, and rightly so for the longest time. I mean, I don't even actually go into defending when there are a stark contrast between what would happen in Paris and Singapore, or not, yeah, Singapore, Hong Kong, or maybe New York courts, and what sometimes our Indian courts will do, maybe because of, for whatever reasons. But speaking of improvement, I administered about 12 Indian cases which were in injunctions in the last 5-7 years, and all 12 of them in the last 8 months have come out of injunction and gone to arbitration. So that's a visible change. There's a lot of talk about the new act, which seems to be a very progressive. Yes, some people call it progressive, some people don't call it so progressive. But yes, it's a way forward in the new direction. The opening up, which was last discussed in the Paris Arbitrators Forum, was the opening up of law firms for international arbitration in India. So yes, I mean, there are some really good positive vibes coming for the international arbitration community, which I hope is you guys will be a part of it soon. So yes, I mean, good things are happening, which are very visible and being acknowledged all around the world.
So before we conclude, are there any remarks from the floor? Any further questions from the floor? Any further remarks or questions from the panelists? Thank you so much for your time, guys. Ladies and gentlemen, to be more politically correct. Since this is mostly a student crowd, I would say thank you so much for your time, guys. This was a pleasure for all of us, especially for ones who have flown in to Delhi for this. It's a lovely time of the year to be in Delhi, nice weather. So thank you so much.
We'd like to thank the speakers. The high tea schedule in the auditorium. We request everyone. Sorry. The high tea schedule.
Yeah, we just, as a part of formality, which is, I think, essential, what must be done must be done. I know we've exchanged a lot of pleasantries and we've given a lot of gratitude, but I think one thing that Sonal and I have been entrusted to do, and I think this conference would be incomplete, at least on our part, if we do not do that once again, and very stressfully, is to thank everyone. A lot of people have thanked a lot of people before, but I must tell you that it is not always easy to fly down, to come down from different parts of the world. Akshay, I called last Thursday that you need to be in India today, and he's flown in last night, and he's going to today morning, he's going tonight, he'll be in office tomorrow morning. Smita has come from Singapore also. Sonal, of course, he's here, but I mean, he's been organizing it for the longest time, and Sonal is a part of this YAF. Sonal is the regional representative of the ICC of YAF, and he's been working very hard to make this program come through. Martin, of course, has come from Hong Kong, which is a long flight, and I was going to go back. We requested him to stay back to judge the rounds, but he's not being able to do that. So thank you so much for coming all the way from Hong Kong. Alexander, who is on this Viz voyage, he will go for another ICC event. I think where would that be? Istanbul, and then probably he's been a Viz. Yes, so he's been there for 10 years. I'm still a baby Viz voyager, but this is my 4th year at the Viz in Vienna. But yes, I'm following the footsteps. So thank you so much, Alexander. Sonal, would you like to thank
Yes, actually, there's a lot of people to thank, so we thought that we divide this work amongst ourselves. So I think, we should thank you all for being so patient with us today. I know everyone is willing to join for the high tea and go back, to their respective homes. So thank you so much. We have been a wonderful audience. I would also like to thank the NLU for hosting us. Of course, the keynote speaker is not here, but yes, it was very nice of him to come over here. And all my fellow panelists, for sharing their views. It was very enlightening and very knowledgeable, and I hope that you all have been benefited by it, and you would be benefited in the moot court competitions as well. So thank you so much, and wish you all a very happy Holi. Play hard, don't worry about the water, and that's absolutely fine. Take care.
Just one unsolicited advice that I'd like to give. A lot of students are now venturing into international arbitration, and a lot of people are going out doing LLMs. Since this is purely a student crowd, and all of us are here, it is not always very easy to get into this niche field of arbitration, but it's also not impossible. So just continue attending events, make yourself more aware of international arbitration. Keep taking part in events, moots, write. Try doing a master's, but yes, there's a lot of scope, and there are a lot of good things that are happening, which we spoke about all around the world, and so there'll be more opportunities coming. Keep at it, stay at it, and best of luck.